In my 40 years on the bench, I've seen every kind of attitude walk through those courtroom doors: fear, regret, anger, even embarrassment. But what made this case memorable wasn't just the disrespect. It was who that disrespect landed on: a 69-year-old veteran who carried himself with dignity while being mocked like he didn't matter. I remember looking at the young woman in front of me and thinking, she still believes privilege is a shield. Let me tell you how that day unfolded. When this case landed on my desk, it came in like many do: paperwork, charges, a short narrative that doesn't tell you the whole story until you dig in. The allegations were disorderly conduct, harassment, and a related assault charge stemming from an incident outside a downtown building where a veteran volunteer was working as a greeter and security support for a community event. The victim, Mr. Harold Thompson, was 69 years old, a veteran, the kind of man who doesn't raise his voice, doesn't posture, doesn't demand attention. He'd spent much of his retirement volunteering, helping with local events, assisting seniors, doing the quiet work that keeps a community stitched together. The defendant was a young woman, early 20s, identified in the reports as the daughter of a wealthy tycoon, someone with a public profile and a family name that carried weight in certain circles. But I've been doing this long enough to know something important. A famous name doesn't change the facts. What concerned me most, reading the initial reports, was not just the alleged physical contact, it was the tone. Multiple witnesses described her as mocking, smirking, and treating Mr. Thompson like he was disposable. That combination, disrespect and power, can turn ugly fast. And I had an initial thought I've had too many times: if she can do this in public, what does she do in private? 3. The incident, 400, 700 words. Here's what happened that afternoon, as I understood it from the evidence. According to witnesses, the event was busy. Families, seniors, volunteers, a line forming at the entrance. Mr. Thompson was positioned near the doorway, helping direct foot traffic. He wasn't acting like a police officer. He wasn't carrying himself like someone looking for confrontation. He was doing a job that requires patience, telling people where to go, reminding them of basic rules, and keeping the flow moving. The defendant arrived with a small group of friends. The report said she was visibly irritated, impatient before anyone even spoke to her. The event had a posted policy: no entry through that door without a wristband, issued at a table around the corner. Simple. Mr. Thompson told her, politely, that she needed to walk to the table first. According to one witness, she responded with a laugh and said something like, "Are you serious? You're kidding, right?" Mr. Thompson stayed calm. The footage showed him gesturing toward the table and repeating the instruction. This is where it starts to turn. The reports described her leaning in, close enough that it made Mr. Thompson step back, and then she began mocking him, calling him grandpa, making comments about how slow he was, and telling her friends, loud enough for people nearby to hear, "This is why old people shouldn't be in charge of anything." When I read that line, I felt something in my chest tighten. I've presided over cases involving violence, theft, and serious harm. But there's a particular ugliness in humiliating someone who's done nothing to deserve it, especially an elderly veteran doing volunteer work. According to the statements, Mr. Thompson tried to de-escalate. He said, "Ma'am, I'm just trying to help you. You'll be right in if you get the wristband." And she replied, again, according to multiple witnesses, "I don't take orders from you." Then she tried to push past him. The security footage showed Mr. Thompson putting one hand up, not grabbing her, not striking her, just a stop gesture, a clear boundary, and then it happened. She slapped his hand away and struck him across the face with the back of her hand. Not a punch, but enough force that his head moved and he stumbled half a step. When I watched that video, I couldn't believe what I was seeing. Not because people don't lose their temper, they do, but because of how casual it looked to her, like she was swatting away an inconvenience instead of hitting a human being. This is where it gets worse. Witnesses said she laughed afterward. Laughed. While Mr. Thompson stood there blinking, trying to steady himself. I've been doing this long enough to know that when someone laughs after harming another person, you're no longer looking at a momentary lapse. You're looking at a character problem. As I continued reviewing the evidence, I did what I always do. I tried to see the full picture. Not just one clip, not just one statement, but the whole chain of events. There were multiple witness statements, volunteers, attendees, staff. What stood out was their consistency. Different people, different vantage points, but the same description. Mocking language, a refusal to follow basic instruction, and a strike delivered with arrogance. The medical report wasn't long, but it mattered. Mr. Thompson had facial redness, tenderness near his cheekbone, and a mild headache. At 69 years old, a blow to the head is never nothing. It can become something quickly. And then there were the details afterward. The defendant didn't immediately apologize. She reportedly demanded entry anyway, insisting that people like her shouldn't have to wait. She argued with staff. She filmed portions of the aftermath on her phone. She was eventually escorted away and cited. What struck me most wasn't just the act of striking him. It was the absence of humanity afterward. When someone hurts another person by mistake, you see panic, you see concern, you see the instinct to make it right. Here, what the file described and what the video supported was entitlement, the belief that rules are for other people and that other people are props in your life. And I had to ask myself, what lesson does the court have to teach when the basic lesson of respect was never learned at home? By the time this case came to my courtroom, the incident had spread far beyond that doorway. Someone had posted a clip online, short, cropped, the kind of thing that spreads fast because it makes people feel something. And they did feel something. My clerk told me it was gaining traction and that people were furious. Veterans groups were commenting. Community pages were sharing it. People were asking, will she get away with it? I understand that reaction. People want reassurance that decency still matters. But here's what I tell everyone. It doesn't matter if 80 people saw it or 8 million. In my courtroom, the process stays the same. Public anger doesn't write my decisions. Sympathy doesn't write my decisions. The law does. The facts do. And I'll tell you another truth. Viral attention can distort reality. It can turn a courtroom into a stage in people's minds. It can make a defendant think they need to perform instead of reflect. I don't allow that in my courtroom. I'm not interested in the internet's version of justice. I'm interested in actual justice, measured, fair, and grounded. And I was determined that Mr. Thompson would be treated with dignity from the moment he entered my courtroom. When the defendant walked into my courtroom, I could feel the energy change. The gallery was fuller than usual. There were older men sitting together, some wearing caps that indicated service. A few members of the local press were present, and Mr. Thompson sat quietly in the front row, hands folded, posture straight, a bruise still faintly visible along his cheek. I always pay attention to that, because victims don't always look like what people imagine. Sometimes they look ordinary, calm, steady, but that doesn't mean the harm was small. It means they're resilient. The defendant entered with her attorney. She looked polished, confident, not nervous. And I've learned something over decades. Nervousness isn't guilt, and confidence isn't innocence. But demeanor tells you whether someone understands the seriousness of where they are. I looked at her and said, "Good morning. Step forward and state your name for the record." She did, flat, almost bored. I said, "You understand you're here because of an allegation that you struck Mr. Thompson, a 69-year-old veteran, and then harassed him." She responded, "I mean, that's not what happened." I nodded. "All right, then we'll look at the evidence, and we'll listen. That's what court is for." Her attorney asked to speak. He was respectful. He explained that his client felt blocked, that she believed Mr. Thompson was being overbearing, and that she regrets how things escalated. I let him finish. Then I said, "Counsel, I appreciate your professionalism, but feeling blocked is not a legal defense to striking a person. Let's hear from Mr. Thompson." Mr. Thompson stood slowly, and when he faced me, I could see he wasn't looking for revenge. He was looking for acknowledgement. I said, "Mr. Thompson, thank you for your service. Tell me what happened in your own words." He spoke calmly. "Your Honor, I was volunteering. I told her where to get a wristband. She started laughing at me. I tried to keep it calm. Then she hit me. I didn't hit her back. I didn't expect that." That line, "I didn't expect that," it stayed with me. Because that's what decency sounds like. It's the disbelief of someone who wouldn't do that to another person. I turned to the defendant and said, "Ma'am, did you hear him? He was volunteering. He was giving directions. And you struck him." She sighed and said, "He was acting like he owned the place." I shook my head. "No, he was acting like a volunteer trying to help. The video will show us what happened." We played the footage. I watched it again, even though I'd already reviewed it. There's something about playing evidence in open court. It removes excuses. It removes imagination. It puts the truth on the screen where everyone can see it. The clip showed her stepping close, talking loudly, gesturing. It showed Mr. Thompson's calm posture. It showed his hand raised as a stop gesture. Then it showed her striking him. I paused the video at the moment of contact. I said, "Ma'am, is that you striking Mr. Thompson?" She hesitated. "It looks like it." I said, "No, not it looks like it. It either is or it isn't. Is that you?" She said, "Yes." I said, "All right, why did you do it?" She said, "I didn't mean to hit him that hard." I nodded slowly. That answer tells me something. You're focusing on the degree, not the act. The question is not whether you meant to hit him hard. The question is why you felt entitled to hit him at all. Her attorney stood again, trying to redirect, saying she has no prior record, that she's willing to do community service, that she's embarrassed. I listened. Then I said, "Embarrassment is not the same as remorse." The defendant looked at me sharply. I said I didn't mean it like that. I kept my voice steady. "Ma'am, your intention doesn't erase his experience, and the court cannot ignore the message you sent that day, that an elderly veteran is someone you can mock and strike without consequence." Then my bailiff approached the bench. He handed something to the clerk, and my clerk leaned in and quietly explained what it was. Screenshots, time-stamped, attributed to the defendant's account. I looked at them carefully. I always verify context before I address something like that. Then I looked at her and said, "Ma'am, did you post about this incident on social media?" She rolled her eyes. "Everyone posts." I said, "I'm not asking what everyone does. I'm asking what you did." She responded, "Yes, I posted." "So what?" I took a breath. I could feel my blood pressure rising, not because I was angry, but because I was disappointed. Disappointment is heavier than anger. Anger burns out. Disappointment stays. I said, "Here is what you posted, time-stamped after the incident. You referred to Mr. Thompson as some old guy and wrote that he was dramatic. You also wrote that you were not getting in trouble over a volunteer." She smirked. It was a joke. I looked at her for a long moment. I said, "Let me tell you something. If your idea of humor is humiliating a 69-year-old veteran you struck, then you don't understand humor, and you don't understand humanity." The courtroom was silent. I could hear papers shifting. I said, "Social media has taught people something dangerous, that you can do harm and then hide behind a caption. But real life doesn't work like that. A post doesn't undo a slap." I turned to Mr. Thompson. "Mr. Thompson, how did it feel to see that posted?" He swallowed. "Your Honor, my grandson saw it. He asked me why that lady hit me." That broke my heart, because now we weren't just talking about a moment outside a doorway. We were talking about the ripple effect, how disrespect spreads through families, how humiliation travels. I looked at the defendant again. I said, "Ma'am, you had choices. You could have walked to the wristband table. You could have waited 30 seconds. You could have spoken with respect. You could have apologized immediately. Instead, you chose mockery. You chose force. And then you chose to broadcast it." She started to tear up. "I didn't think it would get big." I said, "Well, that tells me you were worried about attention, not about what you did." Then I softened my tone, because this is where a judge can still reach someone. I said, "Ma'am, I'm going to give you an opportunity right now. Look at Mr. Thompson and tell him what you should have told him that day." She turned toward him, eyes wet, and for a moment the bravado slipped. She said, "I'm sorry. I shouldn't have talked to you like that. I shouldn't have hit you." Mr. Thompson nodded once, quietly. No celebration, just acceptance. And I remember thinking, this man has more strength in that nod than she has in all her entitlement. But an apology, while important, does not erase a crime. And my responsibility as a judge is not to be impressed by late remorse. My responsibility is to protect the public and uphold the dignity of the law. I said, "Thank you for saying that. Now we're going to talk about consequences." I've been on this bench long enough to know that the right sentence is one that teaches, protects, and, when possible, rebuilds character. I looked at her and said, "Ma'am, I want you to understand something." I paused. I've been a judge for 40 years. I've seen thousands of defendants. Some are remorseful, some are scared, some genuinely made mistakes. I paused again because I wanted the words to land. You mocked a 69-year-old veteran who was volunteering. You struck him, and then you went on social media to make it smaller than it was, calling him dramatic, calling it not a big deal. I leaned forward slightly. Let me tell you what's not a big deal. Mr. Thompson served this country. He's 69 years old. He was doing something good for his community when you humiliated him. I let the silence hold. At 69 years old, that kind of impact isn't nothing. The bruises aren't nothing. The humiliation isn't nothing. Then I said the line I wanted her to remember long after the courtroom doors closed. This sentence isn't about punishment. It's about teaching you what you should have learned long ago: respect, accountability, and that your actions have consequences. I continued, carefully and realistically. Here's what I'm ordering. First, you will be placed on probation with strict conditions, including no further violations and compliance with all court directives. Second, you will complete a court-approved anger management and empathy-based counseling program, and you will provide proof to probation. Third, you will complete community service in a setting approved by probation, work that serves elderly residents and veterans support organizations, so you spend time around the very people you dismissed. Fourth, you will write a letter of apology to Mr. Thompson that reflects understanding, not excuses. Your attorney will submit it to the court for review before it is delivered. Then I looked at her and said, money can buy comfort, it can buy access, but it cannot buy character, and it cannot buy immunity in my courtroom. I added one more statement, firm but hopeful. I hope you use this sentence to decide who you want to be, because the person you were that day, the person who mocked and struck an elderly veteran, that person is not who you should become. After I delivered the sentence, the atmosphere shifted again, less tense, more settled, like something had been put back in its proper place. Mr. Thompson remained composed. That's what impressed me. He didn't look triumphant. He didn't look like he'd won. He looked like a man who simply wanted the truth acknowledged and the system to work. When court adjourned, he approached the bench area with permission. He said, "Ningsim, thank you, Your Honor." And honestly, I thanked him. I said, "Mr. Thompson, thank you for your service, and thank you for your patience. You handled yourself with dignity." The defendant left quieter than she came in. The tears were real now, not theatrical, just the realization that consequences are real, and that the world doesn't bend because you're accustomed to being catered to. Later, my staff mentioned that the ruling was spreading online too. People were responding strongly. Many grateful, some critical, all engaged. But I told my clerk something I've believed my whole career. I didn't do this for comments or views. I did it because it was right. The law has to mean something, especially for the people who think it doesn't apply to them. And I hope the defendant would do what I've seen some people do after court: go home, sit in the silence, and begin the difficult work of changing. Because real change is quiet. It doesn't look like a post. It looks like humility. Let me tell you what I hope people learn from this case. First, how you treat the elderly and veterans says everything about your character. These are people who carried burdens so others could live freely. They deserve respect, not ridicule. Second, social media can tempt people into cruelty. You can turn someone into a punchline with one post, but that doesn't make it harmless. It makes it easier to forget you're hurting a real human being. And finally, accountability matters. In my courtroom, I don't care what your last name is, who your family is, or what kind of money you come from. What matters is what you did, and whether you're willing to take responsibility for it. After 40 years on the bench, I still believe this. Respect isn't optional. Accountability isn't negotiable. And the dignity of people like Mr. Thompson must be defended every time.